This is an audio-visual interview with Professor A. James Casner. It is taking place in the Mayflower Hotel on May 16, 1990, during the ALI's annual meeting. Professor Casner yesterday submitted his tentative draft on donative transfers, completing more than a half-century of service as an ALI advisor, reporter, and consultant. Jim, if our research is correct, you started with the ALI as an advisor in 1936, dealing with Chapter 7 and the general revision of Volumes 1 and 2 of the first Restatement of Property. How did this association start and come about?
Well, I'd like to go back a little bit before the dates you mentioned in 1935 and 6. When I was teaching at Maryland, the first contact I had with the American Law Institute was doing the state annotations to the Restatement of Agency. And that's what brought my attention particularly to the American Law Institute. But my real work for the Institute, of course, came a little bit later, as you suggested in your comments a moment ago. The way things developed for me was that after teaching in Maryland from 1930 to 1935, I felt the need of doing some graduate work at some place. So I applied for a graduate fellowship at Harvard, and I applied for one at Columbia. I received an invitation at both places, but the one at Columbia attracted me more because of the person who was then the reporter for the Restatement of Property, namely Richard Powell, professor at Columbia. Because my field of interest was property, I had been teaching property for some 6 years. If I can just regress for a moment how I got into teaching and teaching property, because that was somewhat accidental too. I was graduating from the University of Illinois College of Law in 1929. And of course, Paul, you're too young to know what the general economic condition was in 1929, but it was rather difficult to get any job as a lawyer, and if you got one, you was at a rather low salary. So I was asked by Jim Harno, who was then dean of the law school, to stay on after graduating in 1929 from the College of Law and teach the courses that were being taught by a Professor Summers, Walt Summers. And they were all property courses. So that it was accidental that I started teaching in property at all, because to take teach during this one-year absence of this professor. And I was offered a salary of somewhat like $4,000 to teach that year. And the job offer I had to go into practice was $150 a month. I was married, and so that sort of the money induced me to go into teaching, although it never had occurred to me before then to go into teaching. After teaching for that year, during the course of that year, I went to the sort of slave market that we had where teachers, people want jobs at teaching would go, and the meeting was down in New Orleans, the meeting of the Association of American Law Schools. And while I was down there, I met the then dean of the University of Maryland Law School, and they had a vacancy in the property field, and they invited me to come to Maryland. Well, that was another development that never occurred to me at all. In fact, on the way down to New Orleans, I'd stopped in Atlanta and visited with the law firm of Sutherland and Tuttle. and the idea of going to Atlanta and the practice of law at the end of the year at Illinois. But I went on to New Orleans, and I got this offer to go to Maryland, and I accepted it. And I got a rather substantial raise in salary. And this was during Depression, I mean, where people were not teaching and getting jobs. So again, the money side of the thing sort of induced me to go to Maryland and not give up and go out into practice. And so after 5 years at Maryland, as I indicated earlier, I felt the need of getting away and doing some graduate work. And I ended up at Columbia for the year 1935-36 and worked with Dick Powell, the then reporter for the Restatement of Property. Dick evidently took quite an interest in me because he invited me to attend some sessions of his meetings with his advisors during that year, and I went to several meetings and was asked to stay on as an advisor for what was then Chapter 7, as you indicated, and the general revision of the first 2 volumes of the Restatement. And I worked in that capacity, but at the end of my year of graduate work at Columbia, I got the offer from Illinois to go back to Illinois as a teacher. But there was no opening in teaching property. But I wanted to go to Illinois again. My family was there. I grew up there, and so it was a natural thing for me to want to go back there. And so I went back to Illinois and took on teaching constitutional law, public utilities, and other public law courses, no property courses. But at the same time, I continued in my capacity with the Restatement, and I would teach public law all week, and on the weekends go out to one of these property meetings with the Restatement work. So I kept up my interest in the property field as a result of that. This was in 1936 when I went back to Illinois after finishing the year of graduate work at Columbia. And in the summer of 1937, I guess it was, I was asked to go up to Michigan, to Ann Arbor, to teach in the summer program. This was obviously a look-over job. I mean, you used summer teachers that they invited in to look them over. And Dean Station was then the dean of Michigan. And we spent the summer there at Michigan. It was very enjoyable at Ann Arbor. And Professor Martin from Ohio State was there. He was another property man. So we had a very enjoyable experience. I remember during those days, particularly at Ann Arbor, if you wanted to have a drink, you had to pull the shades down in your house. And we found after being there a while, there were only a few places where if you were invited out for dinner, that you'd get a cocktail anyway. And it was a pretty dry area. But I enjoyed Ann Arbor. And I went back to Illinois. I didn't get any permanent invitation to stay at Michigan, but I went back to Illinois at the end of the summer teaching. And then I got the offer during that period to go out to Stanford in the next summer. And it was, again, obviously, one of these things where you were going around to summer teaching to see if you could make an impression on somebody that they might give you an offer better than the one you had. And all this time, I was still working on the Restatement, even though I was teaching in the public law area. But both at Michigan and at Stanford, I was back teaching in the property field in the summertime. And on the spring of 1938, before I went to Stanford, I got the offer to go to Harvard. And of course, the offer to Harvard was largely due to the fact to Bart Leach, who was one of the members of the group on the Restatement of Property that I had been working with. And if I hadn't been on the Restatement work and hadn't met Bart Leach, it would have been doubtful whether I would have ended up at Harvard. But at any rate, we got this offer in the spring of '38 to go to Harvard. And so the trip to Stanford was just a lark. We didn't have to feel we had to impress anybody. When the summer was over, we had to go all the way from Palo Alto across the country to Cambridge. And I was to teach in Cambridge, at Harvard, the property field again, so I was back home where I belonged, in that regard anyway. We arrived in Cambridge, and about a week or so later, the 1938 hurricane hit Cambridge, and it was really a very demolishing hurricane. But we lived through that. When I was invited to go to Harvard, I asked for a leave of absence from Illinois because I was on tenure at Illinois. I was an associate professor with tenure status, and they granted that to me for 1 year. And I went to Cambridge in the status of a visiting professor. There was no permanency attached to it. But at the end of the first year at Cambridge, the question came up as to whether I would go back to Illinois because my visiting professorship at Cambridge had ended. And I was asked by the faculty to stay on, not on a tenure position, but to stay on as an assistant professor without tenure status. Well, I had to face the decision whether to give up a tenure position at Illinois or stay on at Harvard for what was just another trial period. The first year that I went to Harvard in 1938, I was about the only visiting professor, I think, on the premises. And I was the first time any young man had gone to Harvard who wasn't, I think, a graduate of the Harvard Law School. They had some senior professors like Ralph Baker, who was at Pennsylvania, that had come up, but they were senior men when they came on the faculty. And so it was somewhat of an experiment for Harvard to see whether anybody that hadn't gone there to law school could be acceptable and come up to the standard that they expected. Well, as I say, at the end of this first year, they asked me to stay on as an assistant professor without tenure status. At that same year, there was added to the faculty 3 other men. One was Paul Freund, and one was Milt Katz, and the other was Lon Fuller. So there were 4 of us that had the status of assistant professors, but I was in the second year of being there, and they were in their first year of being there. At the end of that year in 1939, I guess it was, I went there in 38, the end of 39, they had to make up their mind what they were going to do with these 4 people that were in the status of assistant professor. Because at that time, unlike it is now, you either made it in a hurry or you didn't make it at all. They made up their mind pretty fast because they didn't have assistant professors hanging around there very long. And so there was a long faculty meeting near the end of 1939, and it was quite clear that there wasn't any problem so far as Lon Fuller was concerned. He was nationally known for his work in jurisprudence, or Paul Freund, who graduated Harvard Law School, and Milt Katz. But I found out afterwards that most of the meeting was related to me as to whether I would stay on or not. But they finally, I guess over considerable objection from some people, I never inquired who they were, took a chance, and I stayed on. And of course, that was I made a full professor at the end of 1939 and stayed there in that capacity until I retired from teaching, at least, in 1977.
Harvard was never the same after that.
I think probably not. Of course, since then, they've at least taking a chance with other people that didn't get their undergraduate work. But you know, when you got on the faculty at the Harvard Law School, they still didn't want it to be a person that didn't have a degree from Harvard. So they gave me a Master of Arts degree when I was given tenure, and therefore they could still say that nobody who's teaching at Harvard that didn't have a degree from Harvard at least. I don't think they do that anymore. But to get back to the restatement work, going back in 1936 when volumes 1 and 2 were published, as you indicated earlier, I worked as an advisor on Chapter 7 and as an advisor on going over the entire 2 volumes, because there had been some years in the process of making. In fact, the restatements on these volumes 1 and 2 started in 1927, and Harry Bigelow of Chicago was the original reporter. And when he became Dean of Chicago, I think in 1929, around that time, Richard Powell was made the reporter to succeed him. So that, but Bigelow stayed on as one of the advisors to the restatement.
You're quite right. It says Bigelow reporter, January 27 to June 29.
Right. And that was it was an extremely interesting experience for me, because as a young man, I found myself attending meetings with respect to these first 2 volumes of the restatement, and the list of reporters, advisors, was almost a who's who of the professorial people of that time. One of the advisors was Harry Bigelow. He stayed on as advisor. I don't know whether, I guess you never knew Harry Bigelow, but
no.
He had a kind of a tick. And when we talk, his head would do like this all the time. And therefore, you couldn't be sure whether he was shaking his head at approval or until he started to speak. But it was something that when you talk directly with Harry, and he'd start to shake his head, you'd almost start, your head would almost start shaking too. But he was a wonderful person. He was a magnificent person. There was also in that group, that initial group that I was fortunate enough to work with, Charlie Clark, who later became Dean of Yale, Everett Fraser from Minnesota, of course, Dean of Minnesota later, Warren Madden from Pittsburgh, Ollie Rundell from Wisconsin, Symes from Michigan, and a practicing lawyer named Sims from someplace down south. But that was certainly the cream of the crop so far as property teachers were concerned. And in addition, of course, there was Bart Leach from Harvard.
I think it's interesting that there were always, as I look at this list, 2 practitioners, Sims and a chap by the name of White.
White, of course, I never got to know him particularly, but Upson Sims attended lots of our meetings. But this was entirely a pedagogical group. There's no question about it.
That's a little different today. Most projects have quite a few practitioners as well as academics.
Yes, that's true, but I still think the academics pretty well predominate in the kind of work that is done and in the leadership that's established. Back in those days, you wouldn't think of having a reporter that wasn't a professor, but I think now there are reporters that are not professors.
Was Lewis in attendance at these meetings? William Draper?
Yeah, William Draper Lewis was the director, and of course he attended all of them. And many of our meetings were up at his place up in Maine. It wasn't the Bar Harbor, but another name that ended in Harbor, Northeast Harbor.
Northeast.
And he had a big house up there, and so in the summer we always went up to a place called Astiku Inn, which is at Northeast Harbor, and had our meetings there, and he, of course, presided as the director of the meetings. At least he was there at all of them. William Draper Lewis was a very interesting person. He never remembered your name. And in fact, he would almost invent names when he's calling on somebody. And you have to respond, and no sense in trying to correct him because he wouldn't remember it the next day. For some reason, he just didn't bother with names.
It's like Buddy Ryan, the coach of the Eagles. He never remembers the names of his players. He gets them nicknames.
Well, that's about what William Draper Lewis did. We had a meeting one time in Cambridge of this group, and Mrs. Lewis was along, and we had a gathering, an evening out at our house in Belmont. And it was in the winter because there was all snow on the ground. And we lived up on a kind of a hill and rather steep incline going down to the road. And when the taxi came for the Mr. and Mrs. Lewis, I tried to help Mrs. Lewis down this terrace down to the taxi. And we slipped and we rolled down the hill together, all the way down this hill to the taxi cab. And she was a good sport and didn't mind that very much at all.
Did Lewis participate extensively in the meetings, or?
No, unlike Herb Wexler as a director, and certainly like the present director, Hazard, Jeff Hazard, he just more or less presided. He didn't really take an active part in the discussion. His technical field was not the property field anyway, but he didn't do more than just sort of preside at the meeting and keep order. But I don't recall offhand any real contribution he made to the substance of the material that we were talking about.
Did Goodrich do more than that when he was director?
Not a great deal. Not a great deal. Not nearly the extent to which Wexler and Hazard participated in the formulation of real important decisions from time to time with respect to the material. And that is true even though Herb Wexler was not a property man. He was, of course, in an entirely different field. And Jeff Hazard's background is not necessarily in the property field. But they both had a knack of seeing what was really causing the difficulty that we were arguing about, and being able to step in and make a suggestion, at least, that would move the thing along. And that's a real art, of course, when you're not versed in the field technically, to be able to sit in a meeting and follow what's going on and then make a contribution that the experts haven't been able to work out for themselves. And I think that technique did not really develop until Herb Wexler came along to any great extent. I think Draper Lewis and William Draper Lewis and Herb Goodrich probably didn't think of themselves as that being their function, particularly.
How about the presidents? Were they like Pepper, Senator Pepper? Did he attend these meetings at all, or?
He never attended the meeting of the advisors. Of course, every time I was up on the platform presenting material at the annual meeting, either George Wharton Pepper presided during the early years here, or sometimes Judge Hand, Learned Hand, presided. I remember one time when I was up there when Learned Hand was presiding at the annual meeting, and somebody got up and made some kind of a long statement, and Pound sort of said, Hand sort of the side of his mouth, "How do we shut this guy up?" Now, he was not disrespectful, but it was just that there's some way to get the meeting going forward rather than listening to somebody with a long harangue about something that he didn't know much what he was talking about himself, probably. Now, these two volumes of, first two volumes of Property were published in 1936. And then we went on to volumes 3 and 4. Going back to volumes 1 and 2, I prepared the index to volumes 1 and 2. And if you've ever prepared an index, it's really quite a job. But they thought somebody that was familiar with the terminology and so forth would be able to do a better index than somebody that was completely outside of the fold. So that The first time I ever prepared an index was for the volumes 1 and 2, and I think it's the best index, of course, of the restatement. There's no question about it.
Without a doubt, without a doubt.
But when we went into volume 3, which moved us into the area of powers of appointment and class gifts and so forth, I had done my doctoral thesis at Columbia on the subject of class gifts. And so it was perfectly natural for me to Powell to give me some more significant role in dealing with that particular area of the law. And in volume 3, I served as an associate reporter on certain segments, particularly in the areas where class gifts were the subject of the discussion. At Columbia, in order to get your doctor's degree, you had to publish a doctoral thesis at that time. I don't know whether that's still true or not. But I finished my graduate work at Columbia in 1936 when I went from there to Illinois. But I didn't finish the doctoral thesis until sometime later. I think it was about 1940. So my sketch of my degree shows me getting my doctorate degree at Columbia in 1940, I think, which was when I finished the doctoral thesis, because I had to put it on one side when I went from out to Illinois to teach entirely new courses, and then when I went back to Harvard to teach, I had to put that somewhat on the side, but I was doing some work on it all the time in connection with the restatement, which is in volume 3, which deals with the subject of class gifts.
Did you publish that as an article? Was that published as an article?
It was published as a book. There's a bound book on the subject of class gifts, and this at that time the area was class gifts was in quite a bit of a state of confusion, and so it was the first real attempt to bring some order out of that extremely important area, because you can't make a donative transfer very well without getting involved in a class gift, because sooner or later the beneficiaries you're trying to describe will be people that are yet to be born or something, and therefore you have to describe them by their membership in some class of relatives. Of course, the subject of class gifts, and I said earlier one time I was doing with class gifts, they thought that was a question of classes of society. It didn't seem to dawn on most people at that time that that was simply the terminology for gifts that where individuals were not described by names, who were beneficiaries of a gift, rather than were described by name, because you couldn't describe. And anyway, if you're making a gift to your children and you simply name the ones that are now alive, you leave out some that may come in as you want to in. So you sooner or later you've got to, if you name A and B, you've got to say, and any other children, then you get a class gift as soon as you use the class gift term.
I remember reading an article when I was a clerk for Goodrich on class gifts. I think it was in the Harvard Law Review. Was that yours, or?
Yes, these articles were first published in the Harvard Law Review, and then they were taken and put into a book form for purposes of carrying out my doctorate degree at Columbia.
Goodrich had a tax case that involved class gifts, and I think you shed all the light that was necessary for him to decide the case.
Yeah, well, it's a very interesting, and then, of course, as you know, and when I got back, which I'll get to eventually, we were becoming the reporter for the Restatement of Property Second, I developed a whole volume on class gifts that we'll get to as we continue this discussion. Now, as you pointed out in your earlier remarks, my tour of duty with the American Law Institute and the restatement was terminated by the war. You know, in 1941, when Pearl Harbor came into the picture, there was a total state of confusion in colleges as far as students were concerned. And they didn't know what to do, whether they should go and enlist or whether they should stay in school. And the then President Conant of Harvard thought that some office ought to be set up to advise students what to do, give them somebody to talk to anyway. And he called me over from the law school, and asked me if I would set up an office in University Hall. This is shortly after Pearl Harbor. And let students come in and talk and do give them whatever help you can. I went down to Washington to see what the opportunities there were for people who were in the status of college students, and particularly law students. And of course they said, well, there's one thing we don't need in the Army are lawyers. And that was about the general attitude at the beginning of the war. There's of course the jobs for court-martialing and things of that sort where legal people were involved. But lawyers as such didn't seem to have much to contribute. And the most advice I could give these students when they'd come into this office I had set up is stay where you are and calm down and stay where you are. Don't jump too quickly. If they want you, they'll come and find you. But just stay until things shake down and see what. And many of the students did that. Some went off, but not many. But I was sitting in this office one day in 1941, later on, right after, Pearl Harbor was 1940, and this was 41, spring of 41. And President Conant's office called me on the telephone and said there's a Colonel DeRohan over here from the Army Intelligence in Washington, and he's looking for some people. Will you talk to him? And I said, sure, send him over. I'll tell him what I can. Talk to him about anything he wants to know. And I said, he came over and I said, what are you looking for? He said, we're looking for some people to come in and analyze the German battle tactics to form the basis of a training manual for our troops. And he said, well, I said, you're not just looking for college students. And oh no, I said, we're looking for people of some status. And I said, well, what are you offering to induce these people to come into Army Intelligence in Washington? And he said, we're offering 2 majorities, that is 2 majors, and 2 captains. 4 of you we want. And I said, all right, we only need 1 more major. And he said, you'll go? I said, sure, I'll go. And so I said, there's only one condition. The other major I'll bring along is a colleague of mine at the law school named Bart Leach. But I want to be sure my commission comes over ahead of his, so I will outrank him. And they had no difficulty in doing that. And so I always outranked Bart. We both went in as majors. I became a lieutenant colonel before he did. I became a full colonel before he did. And he stayed in, though, after the war was over until he became a brigadier general. And that's how we finally got to outrank me as far as the military service was concerned. We were, of course, always very close friends. Every time he got a divorce, he came to live with us. So my children thought him as their uncle or something. And we, of course, wrote, right after the war, we wrote a case book together that has had pretty good success. Casner and Leach cases and text on property. But to get back to my story, the war interrupted I went overseas in 1942, not long after I went into the service, because we went down to Washington and analyzed the German battle tactics and did the work they wanted us to do. And then I decided that I wanted to get out of that and get into a little different kind of activity in the service. And somebody told me they were organizing a command out at Bowling Field to go overseas. And so I went out there and saw the general who was organizing the command. And he said, well, do you know anything about Air Force equipment? I said, no, but I can learn. And he said, all right, here's an OEL, it's an organizational equipment list for this whole command. It's got to be in the Brooklyn Navy Yard for loading, for shipment overseas in such and such a time. And he took me in as what we call A4 of the command, of the headquarters command, which is like in the Army G4, which is the supply and so forth section of the work of the headquarters unit. And so I found an Air Force sergeant, old-timer, and I said, because there wasn't enough equipment to go around at that time. I mean, you had to go fight for what you could get. And I said, you find out at what warehouses this equipment is located, and I'll get some trucks and see it. We'll go down and get our equipment. Of course, it was silly to do it because that meant one command would be fully equipped, the other wouldn't get anything. It wasn't spread around evenly, but things were in a state of confusion. You just couldn't imagine why. So you had to go for yourself. And we got an award as being the first command landing overseas, the best equipped command landing overseas. But a lot of others had to take nothing because of the fact we went down and got it ahead of them.
Another Casner achievement.
So we went overseas and we set this command up in Northern Ireland. It was a training command. Flyers would come over and they would be sent to our bases in Northern Ireland to learn to fly in that atmosphere. And then they would go on to bases over in England. And we were there for several years in Northern Ireland. And we were able to get along because they couldn't set up British things there because there was the animosity between the British and Northern Ireland even existed then. So it was the job of developing this was largely went to Americans. We got along all right. Some of our flyers that would come over, would fly B-17s over, they'd see land and they'd come down, you know, and it'd be Southern Ireland. And we had to go down to Southern Ireland and get them out. And Southern Ireland was, of course, neutral, and they should have been really, I suppose, locked up. But
for the duration.
They operated with by certain things that we left there to let them come out. So we would bring them out and bring them back up to Northern Ireland and get them back where they belong. I remember sitting in the Gresham Hotel in Dublin, and on one side of the room were German officers. They were in there just the same as we were. We were all in civilian clothes, though. When we went overseas, this command, we flew over, and we landed at Limerick in Southern Ireland in civilian clothes, but in our bags were all of our military accoutrement covered over with a sheet. And when we went to inspection, they knew who we were. They'd open the bag and they'd close it, and off we go. So that Southern Ireland, in a sense, helped us more in ways than they might have been if they'd been belligerents, because we got quite a bit of assistance in moving our people around to that part of the country. But I finally, well, right after VE Day, I asked if I could go home. I'd been over there from 1942 until 1945, spring of 45. And I was anxious to get back. I had flown back once to headquarters to present some plans that we were working out, because I moved finally into the planning for the taking over the government of Germany and others when the war was over, and we became a planning division. And I'd gone back to present to Washington the plans that we'd been working on for moving in to take over command when we finally had an ultimate victory. But then I went back. That's the only time I, of course, saw my wife and family out for 3 years was the few weeks and when I came back to Washington. Then, when the war was over, though, I said, well, I've had enough. I want to go back to teaching again. So I was relieved in Europe and sent back to Washington. And when you came back at that time, they gave you what they call rest and rehabilitation leave. And I was sent to Atlantic City where I could take my wife and children to sort of be rehabilitated. Every time you went to, and when you landed in Europe, you had to go through this medical report. They'd take you in and show you what horrible things would happen to you if you got certain kinds of diseases. And I saw that sex lecture about 5 times, I think, during the war. And true, it scared the hell out of you. I mean, what might happen to you. But after this rest and rehabilitation, I thought they were going to let me out, but they sent me to Washington, to headquarters, General Anderson's staff, to work out a plan at the end of the war to make a career in the Air Force attractive for non-flying officers. See, I was a non-flying officer. And, but they knew to build up the Air Force that they weren't going to be able to build it up solely with people who were flying officers. And so I spent from the spring of that year until VJ Day in Washington, working up the plans for trying to make a career in the Air Force attractive for non-flying officers. And I finally got it approved by General Arnold. And I said, now can I go home? And so I was relieved and got back to Cambridge in time to begin teaching in the fall, September program at the law school. And we went on then a year-round basis. So we taught fall, spring, and summer for several years so that people coming out of the service could catch up in the time that they had lost. And that was a very time-consuming job, so there wasn't much time to do anything but teach as you went around the clock.
You came back when, in 46?
45.
45.
See, VJ Day was around September, I've forgotten the exact date.
Around Labor Day.
Around Labor Day. It was right after that that I was relieved. I had finished my assignment in Washington. We lived in Washington, and Margaret, my wife, and the two boys came down here to live with me over that summer when I was here in Washington working on these plans to make the Air Force attractive as a career. And when I turned it in to the general, I said, this makes it attractive for a career, but it's not attractive enough for me.
How'd you get an apartment in Washington?
What's that?
How did you get a place to live in Washington?
Well, that was, again, my friend Bart Leach. He had been down here, and they were giving up a house that he had because he was doing something out in some other time. And so we moved into a house that he had had. It was out here near the hotel.
Wardman Park?
Morgan, yeah.
We were in Washington from 44 to 47.
Well, I
lived in 13 places.
I'll bet you did. But we were fortunate enough to get this one place, and throughout that entire summer, and that sort of got us back to somewhat of a normal life. But the normal life didn't really resume until we got back to Cambridge in the fall of 45, and I started teaching again right after VJ Day.
Did you get right into the restatement again then?
Well, you see, at that time, the first restatement, Volume 4, had been published. It was published, I think, in 1944. So there really wasn't any restatement work right then of the property nature going on that I would have been naturally to be concerned with. And I didn't get back to restatement work until restatement of property second got underway. But in the interim time, I got other kinds of American Law Institute work because the tax area started to move into the picture.
Well, I understand you were an advisor. Well, this was 55. You became an advisor in trusts.
Oh yes, I had done that where Scott was working, and I appear as one of the advisors in some of the published volumes of the Restatement of Trusts. But that was in the 50s. I had that much, but the property restatement work didn't really begin until Restatement of Property second.
Yeah, but in between, there was a little project known as Federal Estate and Gift Tax.
Yes, Surrey was appointed as the overall seer, and the Institute decided it ought to get into the tax field in various ways. There was corporate tax, but the estate and gift tax and the income tax, subchapter J on trust and estates, became a topic under Surrey's overall management. And I was selected to be the reporter for the Institute project on estate and gift taxation. And that volume was published, I think I've got it here someplace, about when...
68 or so?
That was the one that was published in 68, and we had been working on it for some time.
I remember your first draft created a lot of consternation.
Well, this was the problem of the consternation grew out of the fact that I had pointed out in this draft and tried to develop in this draft the idea that you had to pay a tax every generation to avoid. In other words, this was the beginning of the doctrine of generation skipping tax, in the imposition of a tax that you couldn't, by setting up a long-range thing that would go for 60 or 100 years, avoid an additional estate and gift tax. And it was quite a, but if they had paid attention to us in '69 when this came out, we wouldn't have all the complications we got now. What we proposed, and the Institute adopted, was a plan that if you set up a property disposition that would go on from generation to generation, you would pay an additional tax when you set it up, estimated on the basis of the taxes you were avoiding, but you'd pay it up at the beginning, and then no complications as it moved from generation to generation. It was a very simple thing, and now, of course, they didn't accept that, and they tried to work out a system, and we now have the extreme complexity of Chapter 26 of the Internal Revenue Code on generation skipping. But we got our report out, and of course that was. Can you shut that off for a minute?
Just go ahead. We can cut it off. Don't worry. We can excise this part when we come to it. Take your time.
I had as an assistant, as you know, Bill Andrews of my faculty. And we turned him loose on the development of the accessions tax. Well, I continued to work on a straight gift and estate tax, but taking into account the problem how you handle the generation skipping problem. Well, that material was published, and it certainly had some effect, I think, on the development of the tax law, but they didn't adopt what we had proposed, and I think that was a mistake because it's caused extreme complexity, and it wasn't until some years later that you got taxes involved, taking care of the generation skipping problem, and then it was in this very complex state.
Well, you really, as I remember, shook up the tax bar with
oh, yeah,
first tentative, with your first preliminary draft, even.
Well, of course, the idea that I was proposing was one that they fought bitterly. That is, that we ought to be allowed to skip generations, if you effect. And it was such a drastic change at that time in the policy, and by fighting it, they knocked it down, and they got something worse. Eventually, that frequently happens, that you fight, and what started out maybe have been a much more lenient and sensible doctrine, and what finally develops when they try to iron out all the complications that are involved in generation skipping transfers.
I think the war must have done something to you, because after that, each of the projects for the Institute that you undertook, something very significant, different, and important came out. Starting with federal estate, then there was, of course, landlord and tenant.
Yeah, that's what we get to that in a little bit, because that started around 1970, and we just finished this tax thing in 1969.
That's right.
And then we also had another tax thing that I was working on. It didn't come out until in the 80s. That's on the subchapter J, income taxation of trusts and estates.
Yeah, you started in that, I think, in 1979.
Yeah, and it was actually published in 1985.
84, 85.
Yeah. And that was going on at the same time as my work for a restatement of property second. I was running two horses.
I think you set a record as the only reporter that ever was a reporter on two projects for the Institute at the same time.
I think that may be true. I think that may be true. Now, early in 1970, though, they decided that they ought to do something about property restatement again. And at that time, Dick Powell was still alive and was reasonably active. And when the Institute came to me, they said, well, you work up a study as to what ought to be done in general terms in going through a restatement of property second with the material that was covered in the first 4 volumes. And so I went to work on a study. They didn't ask Dick Powell to do it, but I talked to Dick about it. Dick was then, this was 1970, I've forgotten how old Dick would have been then, but he was still around. He been reasonably active. And I was concerned about taking on the restatement of property second and hurting Dick Powell, because I had been, in a sense, his protege in some ways and worked with him closely. And he gave me every opportunity that I had to work in the first restatement as a very young man. And so I thought we ought to start in doing the restatement of property second, if we could, on something that really wasn't covered in the first restatement. And I suggested to the council that we start with landlord and tenant, because landlord and tenant had not been mentioned in the first restatement except in connection with describing the different estates, different tenancies, such as a tenancy for years and tenancy at will and from year to year and so on, but rather brief. And that would not be redoing something that Dick Powell had done. And I thought it would be better, since it should be done anyway, that if I could start with something that would not be going and redoing the work that he had done, that it would not be as serious affront to Dick, because I certainly didn't want to hurt him. And that's how we got, and the council, I didn't go into this analysis about not hurting Dick Powell in connection with the percentage of the council, but I thought it was a sensible place to start anyway. And the law of landlord and tenant had evolved to significant proportions from what it was when we did the first restatement. So that's how we got started in 1970 on the volumes on the restatement of property second, landlord and tenant. And those two volumes were worked on for 7 years, from 1970 approximately to 1977.
And they made some very significant contributions.
I think so, yes. I think it's been very significant. And we had a number of real experts in that field as advisors. This was made up more practicing lawyers than almost any other set of advisors.
Remember the bane of your existence, Mr. Friedman.
Yes, they were somewhat resistant to some of the things that were being done. But I think those two volumes, as far as I know, have been a significant contribution to the landlord and tenant area.
Landlord warranties and
implied warranties, fitness for a particular purpose. Which has developed to a considerable extent, and the whole field of it, which was throwing greater burdens on landlords than previously in connection with certain transactions, so that was certainly, the landlord bar was somewhat resistant to some of the things we were doing. But I think that's a good job that was done.
I think it's one of our best.
But there was some really good advisors on that, though, that people that knew what they were talking about. In that field.
I have the photograph in the office. Mm-hmm. I think I sent you a copy, a color photograph that we took at Seaview of you and all the advisors.
Yeah. Now we're up to 1970 to 77. I might just skip back a little bit because I got involved rather heavily in the problem of lecturing to lawyers, post-legal education. You're, of course, heavily steeped in this problem, have been for a long time, but if you put yourself back in the early 1950s, there was very little going on in the way of developing arrangements for lawyers, in a sense, going back to school. And I conceived the idea in 1953 when the American Bar was meeting in Boston for the first time. It hasn't met there since. I think it's going to meet there in a couple of years from now. Of having Harvard put on a course for lawyers coming to Boston to go to American Bar Association. And we gave the first Harvard program of instruction for lawyers. I was the director of it in 1953. We gave 2 courses. I gave the one on estate planning, and Louis Loss gave the one on, in his field on incorporations. And we had a very large group. But at that time, it was not the usual. One looks at the situation today, you think this was going on all the time. But the idea of lawyers going back to school again, in effect, back to get some additional training after some years out, was very new at that time. And that was the beginning of Harvard getting involved in it. And of course, I remained as director of the Harvard Program of Instruction for Lawyers from that date until 1977. 1976, I guess it was. Then Louis Loss succeeded me, and Professor Hurwitz is now running the program. I still teach in it. I'm teaching this summer in the program. But I think that's been the most successful of the law school efforts on a continuing basis over a long period of time. We get from between 600, 700 coming in.
You know, that got you into trouble with me, though. I got you into trouble teaching when you came to Philadelphia to teach.
Yes, I know. Of course, I didn't just lecture in that program. I would go around the country giving lectures to members of the bar, and I think I was just overdoing it. And of course, I ran into the problem in Philadelphia that you got me there to give a course to lawyers that were here in Philadelphia. And I remember that I was teaching 3 days, and the first 2 days went along all right, and we went out to dinner.
You had spaghetti?
And the end of the second day, and had a big dinner, and I was feeling fine. Went back to the hotel, and I wanted to get up in the morning, and I fell on the floor. And I thought my leg and arm had fallen asleep, like you know, but I found I didn't wake up anyway. And of course, I ended up in the hospital with a stroke. It was in 1984.
Jefferson Hospital, I remember.
Yeah. And it has knocked out my left arm, my left leg, but it didn't affect my speech. You know, if you get a stroke on the right side, it affects the left side, but speech side is on the left side. And fortunately, if you can talk, well, you can do almost anything. It's when you can't talk that you get into difficulties.
Well, I always marveled that it really didn't slow you down.
But now we're through with the restatement of landlord and tenant, and we then come to what we're going to do now in connection with the restatement of property second. By this time, I think it was obvious from the age of Dick Powell that he was not going to be concerned about somebody taking over the work that he had done and going over it again. But I felt in looking at those first 4 volumes that we did not really need at that time to redo volumes 1 and 2. They dealt with the basic development of estates and land and things, and that basic development hadn't changed significantly. The area of real development that I thought needed more immediate attention was the area covered in volumes 3 and 4 of the first restatement. And of those, I thought the first thing we ought to tackle was what was done in volume 4, because I thought we were really ready to get the bar to come along for the wait-and-see rule on the rule against perpetuities. And this was a golden opportunity to try and get some sense into that area with respect to the rule against perpetuities. So we started with the material in volume 4 of the first restatement to become volume 1 of the restatement of second on donative transfers, which was largely developed on the rule against perpetuities.
And the famous debate.
And then, yes, it was at this time, after we developed this material, that Dick got quite upset about tinkering with the rule against perpetuities that had been so admirably presented in the first restatement. And we had it was arranged that he would have the floor of the Institute to oppose the adoption by the Institute of the proposal that, under my reportership, had been worked out on the wait-and-see rule in connection with the rule against perpetuities. And I remember that ballroom at the Mayflower Hotel was packed for 2 days while we argued about the rule against perpetuity, which I thought was one of the most amazing things that particular subject matter could demand that kind of attention and excitement. When the vote was taken and they voted in favor of the proposal I had made on the wait-and-see rule, I really felt very sorry about it, because Dick came to me and he said, "Well, you beat me, Jim." And that was a pretty, it was a very, almost a sad thing for me in some way.
Yeah, but he didn't get any help from his colleague from Columbia.
Not very much, although he got a little help from some of them.
But there was one that I think really did him in.
Yeah, but it was one of the saddest moments of my life, to win something and then feel so upset about it, because he was and is a great person, and he just and of course, if you knew Dick Powell, when he presented something, it was done very vigorously. I mean, it was done very positive, with quite a great deal of dynamism and force, and I felt so much responsible to him for so many things that had happened in my life that it was not a pleasant thing for me to. I never gloated over the fact that it went across. Of course, the idea of a wait-and-see statute rule really originated with Bart Leach. He wrote some articles, and he and I, along with some others, got a statute passed in Massachusetts, which was a modified wait-and-see statute. So that we had done some work outside, getting acceptance of the thing, and the bar generally didn't oppose it, because it made it easier for them to avoid malpractice suits, in the sense because they get caught in the old rule, and the old rule would devastate you. I mean, the wait-and-see rule at least gave you a chance, and we always took the position that if you didn't qualify for the interest after waiting and seeing, that then the court should revamp the disposition so that instead of canceling out the whole thing, they would give you an alternate disposition that would carry out to the attention of the testator to the best of the ability at that time. And of course, that sort of reformation principle has been carried over. Now, of course, the wait-and-see rule swept the country, and the restatement started it. And it has been done by statute in many states. It's been done without dative statute. And of course, the present uniform commissioners now propose a modification of a period of 90 years, a flat 90-year period you wait and see, instead of having to have a wait and see tied into lives and being in 21 years. And that has caused some problems, and because there have been some criticism of the 90-year rule in light of some tax traps that it may get you into. And Duke Manero has been writing some articles about how the uniform commissioners may have created a problem, and that's something that's now under consideration. But I don't think, and that's a statutory change. There's been no promotion of no developed by case law of a flat 90-year rule. So that I don't think that part of our restatement needs to be revised, except that possibly there should be some annotation, maybe, the fact that there is a proposal that's been adopted in some states for a flat 90-year rule for waiting and seeing.
Let's get back to taxes a minute. You made a significant contribution to the marital deduction business, didn't you, with the total transfer?
Yes, that was a part of the tax study we were doing, was to get an arrangement whereby which we now call a qualified terminable interest, where you don't have to give the person the power, give the wife the power to appoint to someone else, where she can give the spouse, the wife, or the husband, as the case may be, a straight life estate without any power to change it, still have it qualified for the murder. That idea started back with our material, and now, of course, has swept the country.
And you made some important changes with subchapter J, too, I think.
Yes, the whole development of income taxation of trust and estates as it's now evolved, and the development of the throwback rule, all was a part of the study that we did on subchapter J. And that, I think, has had considerable influence on the tax law. Of course, Surrey was a great leader of that whole movement, as you know. Stan Surrey, a colleague of mine that everybody knew, had been steeped in the tax law for years. And I was sitting next to him, because he always sat with me when I was up as the reporter. He was director of the whole project. When he had that stroke or something.
Philadelphia.
Was in Philadelphia, someplace, where he blacked out and got into difficulty. And he was sitting next to me, and I turned to him and I said, asked him a question. I said, "Stupid, answer the question I asked." And he was out. I mean, he was sitting next to me right on the platform there.
Yeah, Stanley did a lot for taxes through the Institute over a lot of opposition for a while. Remember
Yes.
Mr. Miller?
Well, Robert Miller, yes, of Washington, was very against us on certain things we were doing, and he was a rather powerful figure in the tax bar at that time. Very powerful. But, some people thought that the things that I was advocating were really fed to me through Surrey, I think, other than that I was the mouthpiece for Surrey, but that was not true, because Stan's strong fort was not in the estate and gift tax area, it was in the income tax area.
Sure. Norris Darrell got us started,
He was a tax lawyer, you know.
In taxes. He was, even before he was on the council.
That's right.
And then they got Surrey and Warren to do the first federal income tax study.
Right, right. I didn't come into the picture until they got on the estate and gift tax.
Then they went to the estate and gift tax. And
see, through this period of time, right after the war, I developed the first course that was given in any law school on the subject of estate planning. It wasn't that the material that is involved in estate planning wasn't being taught, but it was being taught in property, and a separate course in trust, a separate course in conflict of laws, a separate course in income taxation, separate course in the estate and gift taxation. There was no attempt to bring that all together and think it through in the process of doing an estate planning job. And I gave, in 1948, the course at the Harvard Law School in estate planning, and it was the first time a course by that name had been given in the law schools. Well, that, of course, has swept the country, but I started to work on, at the beginning of that time, on what is now my treatise on estate planning, which has grown from one volume in 1951 or 2 into 9 volumes now, on the subject of estate planning. It tries to coordinate these various impacts upon the estate planning decisions that are made. And that was when I was lecturing throughout the country to lawyers. It was always on something in connection with estate planning, and particularly the tax aspects of estate planning.
Jim, how important do you think the contribution of the Institute has been to the development of American jurisprudence?
Well, I think, and
I want some of your general observations.
I can only speak with some degree of knowledge of the field that I'm concerned with, and there's no doubt that through the mechanism of the American Law Institute, we've had tremendous influence on the development of the property. You can write articles here and there and so forth, and they have some impact. But it was the organized effort of the American Law Institute to deal with the statement of the law, and including in the statement of the law to bring out the needs for reforms and so forth, that caused practically everything that's happened of significance in the property field to have been brought to fruition. Now, what would have been done if we didn't have the American Institute, I don't know. Maybe some other mechanism would have been found, but it needed some kind of national push. Now, whether it's had the same significant effect in other areas, I'm not really too much of a judge, too much of being capable of judging. But I think the original idea of the restatement of the law, which in the first restatement became a mechanism of deciding what the weight of authority was and stating the weight of authority, and not opening the door to very much criticism of that, didn't really help it get off the ground as much. It was later when they got the development that we could criticize existing law. We could even suggest that the minority position was the one that the restatement adopted, and that more came along a little bit later. The first restatement was pretty much, you found out what the weight of authority was, and that's what you stated. You could argue over what the weight of authority meant, because Powell, I know, would say, well, I think if we had decisions from New York and Pennsylvania and Illinois, even though there may be some adverse decisions someplace else, that the weight of authority, the weight of authority wasn't necessarily a nose count. And that was injected somewhat in the restatement of property. But the idea of moving out was something entirely foreign to what was predominant authority in the country, and stating it as the restatement, like we did in Rule Against Perpetuities, didn't come along until we were working on the second restatement, pretty much.
I think Goodrich started some of that development, and then Herb carried it forward.
Herb always said, and I know some of the things I've done, I go back to what Herb said, it's perfectly all right to take a statutory policy and say that now has become such a policy that courts ought to do it without the aid of having a specific statute. And that's how we got some of the things in the restatement that, and in this work that I've just been finishing on, where we have pointed out that the policy evidenced by a statute should be carried over into situations not covered by the statute when those situations are identical in respect to what has been. That's how I've gotten into this problem of substitutes for a will that I was talking about yesterday. How that those should take over the body of the policy that is evidenced by statutes that are in terms applicable only to wills when you've got substitutes for a will that are so similar.
Do you think that the membership today is less resistant to change than it was when you first started?
Oh, I think so.
They used to count noses in those days.
I bet there were some that you would always know how they were going to vote almost, and there were some that anything that changed, lawyers were afraid of being educated out, their knowledge being educated out in one sweep out of the Institute. Oh yes, we had much more resistance to change, it seems to me, than the present bar, because the present bar, I think, has gotten adjusted somewhat to the fact that law is an evolving thing. It isn't necessarily static, and therefore you've got to expect sensible changes to be made from time to time. One of the things that has slowed up the work of the Institute somewhat is the widespread development of statutes. See, the Uniform Commissioners on State Laws, they have taken up some of the cudgels here and developed various kinds of statutes. In the field I've just been working on, the Uniform Probate Code deals with most of these problems. What I was trying to do is to say what a court could do even if they hadn't gone to the statutes. That the courts ought to be able to move and develop the same principles that sometimes many people think can only be done by statute. And that idea still hasn't been fully accepted by a lot of people. The idea that I said last week that I thought a court could render a statute obsolete. A court could decide that the statute was passed at a time to accomplish certain things. Those conditions have changed, and the court ought to rule, if that's true, that the statute is no longer effective. Well, that's still a shocking idea to a lot of people. Well, I wasn't able to get it across.
I think if you stayed around for a couple more decades, you might persuade them that there's some validity to that proposition.
Yeah. That's the reason we get so many obsolete laws on the books. It's hard to get the laws off the books sometimes, the legislature to repeal them. And that we would be able to get out from under some of these laws that were passed some time ago that no longer really make sense in light of changed conditions by the courts.
Like that case in Wisconsin, with that woman with adultery, that an old statute, and an ambitious prosecutor decided to prosecute for something that just isn't being done anymore.
Yeah.
Well, Jim, I think you've given us a pretty good overview of the development of the Institute and the important part that people played in it, especially someone like you.
Well, it's been constant with me. I feel that I've been working for the American Institute since 1935 without any real gap. It just seems to me it's been a continuous thing, and it has fed me into various other things. But they all, in a sense, grow out of the fact that I was involved. If I hadn't been involved in American Institute work, I think my history of what I've accomplished would be quite different.
And the history of what the Institute would have accomplished would have been quite different and not as great. Thank you very much.
I enjoyed it. Let's see if I left out anything. Well, I'll turn these over. You can look it over. I think that it is. I think I covered most of the things. If I can go back for just a little bit to this development I've referred to of using substitutes for a will from time to time in place for state planning purposes. The whole development that now has come into the picture of the widespread use of revocable trusts as a substitute for a will really started back in 1960 when I wrote an article for the Columbia Law Review in which I set forth what I thought were considerations that would justify in estate planning the use of revocable trusts rather than the going through probate with a will. And that article became the basis of a movie that the American Bar Association made, I think in conjunction. Was that solely a American Bar Association project?
We published the pamphlet in connection.
That's right. It was some tie-in with you, I know.
And John Creedon, I think, in Metropolitan Life.
That's right. He was the one that pushed this forward and cut up some money. And there's a movie on the revocable trust. And I don't suppose anything has been seen by more lawyers than this. This came out in the 1960s. And it went all over the country, and I would follow it around, giving lectures on it along with it from time to time, and there would be a local panel to comment on local. But it became a medium of continuing education for the bar that was turned out, and there's no doubt that lawyers got educated very quickly on something that might have taken years to put across. Then we made another movie called The Irrevocable Trust, and that was more complicated and got in more tax laws, and that was made in the early 70s. And then I revised both of those, or one of those movies, rather recently, and I don't know what's happened to that now.
Who produced that recent movie? Was that the ABA too?
That was the ABA, and it was done by that organization up in Minnesota. They were the ones that, and I did one with a professor down in Texas on a revision of the revocable trust, sort of bringing the thing up to date and the irrevocable trust. But the movie as a medium of continuing legal education really started with that initial project, and of course now it's been used quite extensively.
And since then, they've developed a lot of videotapes.
Which is another way. It's the same thing in a sense. It's a method of people being able to see what's going on and who's doing it without actually being present.
Right. We'll have to get you down sometime to our studio in Philadelphia to do something for about 15 minutes on some new developments. And we publish these.
I'm a little leery about going to Philadelphia.
We'll come to Boston.
After what Philadelphia did to me.
You're going to come forth. You're now an advisor for property servitudes.
I am. I don't know whether I'm going to be. I'm going to cut down a little bit. I mean, I've been going pretty steady and pretty strong, and I think that while I may do work to some extent, I'm not going to obligate myself to do very much that I've got a full-time job keeping this 9-volume treatise on estate planning up to date. That's really a weekly job. I've got to write up material.
Who does your proofreading now?
Well, I try to do it myself. I don't get any help on that either. I don't use any help anyway. And I'm starting the revision of the Casner and Leach case book with Susan French. I brought her in.
What's Susan, right?
Particularly to do the material on servitudes, and we're hoping that we'll get that revised, and that's a book that's widely used for teaching first-year property.
Are you still working on the American property volumes?
No, the last thing I did on that was to do the supplement in 1976. And there really hasn't been any supplement since then. But I was talking to Little Brown and suggesting that maybe they ought to make another supplement to the book. I think that's a rather basic book. I think it would be foolish to undertake to revise the whole thing. There hasn't been enough change in the basic things that are there. There's a basic property principles. But a supplement could make it use. Again, this is one of the things I ran into that bothered me a little bit with Dick Powell. Right after we finished the restatement in Volume 4 in 1944, right after the war, or even before the war, we suggested that Dick head up a group to do a text, because the practice had been when you finish a restatement that the reporter writes a book, like Scott did on Trust.
Beale did it in conflicts, yeah.
And I suggested, well, why don't you set up a team to do it? And Dick said, no, he wanted to do it himself. And that was all right. So that's how the American Law of Property was born, was the team idea. And I was put in charge of being the editor-in-chief of this, and we had an array of authors. You look over that list of authors, and they're the people of prominence in the field at the time. And they wrote different segments of the book. And that was a pretty big project to keep all those horses running together, to come out at the line at the same time and publish the book. And but that was generated largely as a competitive book to Dick's book on property.
Well, thanks again, sir.
All right.
I'll stop things, and we'll try to put out a finished product in due course.